Hello friends, in my YouTube channel Advocate Amit Kumar Gupta, today I am going to discuss a case which is based on section 263. The name of the case is Bosch Limited versus Commissioner of Income Tax, and this case has been reported in 98 ITR short notes page number 1, and the case has been decided on 29th June 2022. In this case, the assessee claimed allowance under section 32 AC for the investment made in plant and machinery. In this particular case, the assessee acquired the plant and machinery before previous year 2013-14 but installed that machinery during the previous year 13-14. The provisions of section 32 AC says that you can claim the allowance if you have acquired and installed the machinery in the previous year 13-14. But in this case, the machinery was acquired before 13-14. But when the assessment proceedings were going on, the assessee said that there are no cases available on section 32 AC, but on the same lines in section 32 subsection 1 clause II-A, the words acquired and installed are there, and on that section there are a number of the cases which gives assessee the option to claim the exemption if the machinery is installed in the previous year 13-14 and the machinery has been acquired before that, meaning thereby that in that section the benefit to the assessee is given even if the machinery is purchased or acquired before 13-14, but if the machinery is installed in 13-14, then the assessee can claim the benefit. So by taking the ratio of those cases, the assessing officer allowed the allowance under section 32 AC to the assessee. When this allowance was given, the CIT appeal, when reviewed this order under section 263, he said that in section 32 AC, the wording is acquired and installed, but the machinery has not been acquired during the previous year 13-14, but it has been acquired before that. So he made the revision under section 263. The mannerism of section 263 is that if the order passed by the assessing officer is erroneous and prejudicial to the interest to the revenue, then the order can be revised under section 263. But when a order will be erroneous, there are a number of circumstances in which the order can be erroneous, and one of the circumstances is that if the view taken by the assessing officer is contrary to the law, then that order will be considered as erroneous. So the CIT appeal was saying that the view taken by the assessing officer in this particular case is contrary to the law. So that's why he was saying that the order passed by the assessing officer was erroneous. When this matter came to the ITAT said that assessing officer has given due deliberation to the law point decided under section 32 subsection 1 clause II-A, and because in that section the words acquired and installed is there, and in section 32 AC also the word acquired and installed is there, so the ratio of those decisions can be well applied in section 32 AC also, because in that section the cases are not much available. So whatever the view has been taken by due deliberation by the assessing officer cannot be taken that cannot be said that this is contrary to the law, and the revision under section 263 in this particular case is not justified. So the tribunal upheld the order of the assessing officer which has been passed earlier, and quashed the revision which has been done by the Commissioner of Income Tax. Friends, this case is very technical as far as the interpretation of section 263 is concerned, or about the point that when an order is, or we can say that the view taken by the assessing officer is contrary to the law or not. So this case draws a very thin line between the erroneous order passed by the assessing officer. At the end of this video, once again I am repeating the name of the case. The name of the case is Bosch Limited versus Commissioner of Income Tax, and this case has been reported in 98 IPR, short notes at page number 1. Thank you, friends.